Got it. Good evening, everybody. Just waiting a few minutes for everybody to get settled.
We are so happy that everyone is able to join us tonight. We hope that you're joining us from someplace a little bit warmer than Washington, D.C. and New York City.
You're admitting people, Trace?
We are, yep.
Okay.
Give it another minute or so, and then we will get started.
I see lots of friendly faces here. Welcome, everybody.
Hi.
Welcome, welcome. Got a great program for everybody tonight.
Right.
Great. Okay, Tracy, I think we should start. Yep.
All right. Well, welcome everybody. On behalf of Savvy Ladies, we are so excited to be able to present this to you. And we're so excited that you're here. And everyone can see my screen. Is that correct? Good. I'm going to go ahead and tell you a little bit about Savvy Ladies for those of you that aren't familiar. We are here to educate women about finances and everything financial. Our website is a wonderful resource for you all. If you haven't visited it, please do. But what our really special sauce, if you will, is our one-on-one pro bono helpline, where we will match you with a financial volunteer to answer your most pressing question. So we encourage you all to use the helpline. It is there for you and it is absolutely free. And all the programming we offer here at Savvy Ladies is absolutely free. So I will put, once we get into the program, I will put the link to our helpline and our website in the chat, so it'll be there for you to use. But without further ado, I want to get on with the programming since we have a very awesome lineup tonight. And I want to give a very special thanks to our sponsors. We have Our Family Wizard and Elle Bar with My Family Wizard, and Lisa Zeiderman is here from Miller Zeiderman as our two of our speakers. So we are so excited to bring this to you and thank them for sponsoring the series. Just a quick moment of housekeeping. We like to see your smiling faces. So if you'd like to come on camera, please do. We love to see you. We just ask that you stay on mute. This is set up as a webinar format. We will answer your questions as we go along in the chat. And just feel free to type them in there and we will get them answered. If we are unable to answer them tonight, please, again, feel free to come to our helpline and we'll be able to get those answered for you. So without further ado, Lisa, I want to turn it over to you. Not only is Lisa with Miller Zeiderman, founding partner with Miller Zeiderman, she is also the chair of the board of Savvy Ladies. So we're so thankful for her for doing that. And welcome, Lisa. Thank you.
Thanks so much, Tracy. It's great to be here with everybody. Everybody can hear me okay? Yes? Okay, great. And we've got an unbelievable lineup tonight of guests. We have Ellie Barr from Our Family Wizard, who is amazing and a good friend of mine and colleague. And Ellie will be teaching us about Our Family Wizard tonight. Our Family Wizard, we thank you for being a great sponsor and for being a very loyal sponsor, Ellie, so thank you. We also have my two partners, Siobhan O'Grady and Jennifer Jackman. Maybe you want to give a wave, both of you. They are fabulous attorneys and great partners to have, and they just have a wealth of knowledge, having both been actually in the courthouse as court attorneys. So we're very fortunate to have them both. And then Andrea Labus, who is a wonderful colleague, who is a therapist who works with people in terms of co-parenting and therapy, and trying to work in the best interests of your children at all times. And Andrea is a godsend for many, many people because of that. So we're going to get right down to it. And I'm going to start actually with Jen, if I may. And Jen, can you let us know the difference, please, between family court and Supreme Court? Because a lot of people just don't know the difference between the two of them.
Yes. So family court has jurisdiction to hear cases involving child support, custody, visitation, spousal support, and family offenses, more commonly referred to as orders of protection. They also hear adoption proceedings with the surrogates court, and they hear paternity cases for people who aren't married. The Supreme Court is the highest level court in New York. And for purposes of our discussion today, they hear divorces. So family court, they can do everything with Supreme Court, but they can't do divorces. That is something that only Supreme Court would do. I will say also here in New York, if you're in the New York area, New York City has family courts in each borough to help with the distance and the volume so that people don't have to travel. The number of family courts throughout the state of New York depends on the size of the county. So in the boroughs, there's one family court in each borough. In Westchester County, we have three, but in Putnam County, there's only one family court.
Now, Jen, you said it's the highest court, the Supreme Court, but actually there are higher courts
It's the
than the
highest trial
Supreme
level
Court.
court. I'm sorry, Lisa. It's the highest trial level court in New York.
And so if people, for example, don't end up with a decision that they're happy with in the trial court, they can then go up past the trial court, correct?
That's correct. So we have appellate divisions that have jurisdiction over the different trial courts throughout the state, depending on where you are. And if you don't agree with the appellate division decision, you can go to the highest court in the state of New York, which is the Court of Appeals.
And that's pretty rare to do, to go to the Court of Appeals, but the appellate division is something that people regularly do actually utilize. And the difference, Jen, just quickly, the difference between using the appellate court and the trial court, how many judges usually are looking at the information in the Supreme Court?
It's usually just one judge. So when you're before the family court or the Supreme Court, you're dealing with one judge, and we're also dealing with what we call bench trials. So unlike what you see on TV, there's not a jury there. There's only the judge who the lawyers are presenting their case to, and that judge, as the trier of fact, makes the decision. When you go to the appellate division, there's a panel of judges that reviews what is done by the trial court and then makes a decision. And like Lisa said, the Court of Appeals, I like to say that the court doors are open. Well, they're open for family court and they're open for Supreme Court, but the Court of Appeals, they are very selective about the cases that they take. You just can't just walk in there and file a request to look at a case in the Court of Appeals. It's more of a process.
And before I go any further with my questions, I just want to introduce Judy Herbst, who is here actually, and who is the executive director of Savvy Ladies. Judy, I didn't spot you because I know you were going to end up having to leave. So I apologize, but we love Judy. Judy is really, I think, the most important person for Savvy Ladies, who has really taken it to all new levels, and we thank her for being here as well.
I was going to say, Lisa, thank you so much for that. I wanted to say just, it is so wonderful to see familiar faces and familiar names. So thank you so much for coming to joining us for our second panel around getting savvy about a divorce. And this is such an outstanding panel. And I'm so thrilled that Lisa has pulled her team of experts, because it takes a team, and she's bringing that team to you all as as clients and guests of Savvy Ladies. So really soak it all in, ask your questions, fill up the chat with questions. And if we don't get to you, come to the helpline. We are here for you. And thank you so much. And just enjoy the program and just keep asking your questions. That is what Power of the Ask is all about. Thank you.
Thanks so much, Judy. Siobhan O'Grady. So can you give us, in a nutshell, I'm going to ask you one after the other, and if you can kind of go through some of the buzzwords that people hear in terms of custody, and that would be custodial rights. What does that mean?
So custodial rights, custody is really broken down into two separate animals. There's legal custody and physical custody. Legal custody is really who makes large decisions for a child, who's going to decide whether you change a medical provider, whether there's a medical procedure, what school, whether you change, whether there's a tutor involved, things like that. So that's legal decision making or legal custody. And physical custody is where the child sleeps at night, where they're spending overnights, where they spend holidays, what the visitation schedule is. So custody is like a broad word, but there's really two big prongs to it.
Now, with regard to the sole legal custody versus joint legal custody, can you explain what the difference is? And is there some middle ground sometimes also?
Sure. So sole legal custody really means that one party has all the decision-making authority. That party makes, determines what's in the best interest of the child and makes the decision on any of those major legal custodial decisions. Joint legal custody is on the other end of the spectrum and means that the two parties have to agree. They have to mutually agree on taking any course of action. And what that means is if, for instance, my easiest example that I always use is you have a child who may need braces. The orthodontist says the child needs braces. If the parties can't agree that the child is going to get braces, then the child doesn't get braces until you break that tie somehow. So joint legal custody really truly means that you have to jointly agree before taking any action. The middle ground that Lisa's talking about, there's a couple of ways to have almost what's called a tiebreaker. That's the easiest way to describe it. And you can have joint legal custody where one party has final decision-making, which means you consult with each other, you go back and forth, you try to come to a resolution. And if you really are at an impasse, then the party with final decision-making gets like a trump card and can make the decision. And the other one, which is used pretty commonly now, is called the professional model, which is the parties try to agree. And if you're at an impasse, you consult with the relevant professional for whatever the issue is. And then the relevant professional weighs in, and whichever party agrees with that professional makes the final decision.
So Andrea, in terms of the three different types, how do people know whether they should be asking for sole legal custody, joint legal custody with final decision-making, joint legal custody with a professional model? Do you have any words of wisdom so people can make a decision as to what fits best for them? And I know that's a complex question, but I also know that you probably have some ideas about that.
Sure, I'll try my best. I think the first question people have to ask themselves is, can I take my feelings about my soon-to-be ex out of the equation and focus strictly on what my child may need? And can that other person do that too? Can we agree that if the pediatrician says appendectomy, we're not fighting about it? Can we agree that if our child needs a tutor, will we not fight about that? Sometimes people will say, hey, I've been doing this for so many years and that person, that other parent never participated. Well, they are now. So you have to let go of that and have the ability to have meaningful interactions with each other, be child-focused, and be able to make a good decision together. If that doesn't work, then certainly they can fall on a professional model where the doctor says, here's what you need to do, or the teacher says, here's my recommendation. Maybe that will help them agree. If that doesn't work, then sometimes people have a parent coordinator who is a neutral person who doesn't have decision-making authority, but can opine based on the facts what this child needs. And I hope it's not an appendectomy that they're going to this person for, but something that's more subtle, like a tutor or an extracurricular activity, something like that. And that person can opine, and then the parties can agree. And often that works. And if it doesn't, somebody can always go back to court, which I don't advise because people will just fight forever. It's about being able to put your child's needs and wants, frankly. If your child wants to participate in an activity, no matter whose time it on, it's that child's time with you. It's their child's time with the other parent. Can we set aside time and just agree, hey, my child would like to play tennis, my child would like to go to a dance, and not argue about every little thing? Because the argument is an attachment to that coupledom, which people seem to not want if they're getting a divorce.
Now, we see, I'm just going to state this, where decisions, and you can kind of tell right away whether people can make decisions. And I would say the areas that we see people argue the most is on issues of when a child has certain challenges. And so, for example, whether to medicate or not to medicate a child, where there's an ADHD issue, where there is an issue in terms of vaccinations now. I mean, we see this, right, Jen? We see this all the time in terms of vaccinations, whether a parent actually can agree on whether or not to give a COVID vaccination. How many cases like that did we have?
So many. And I would just add that every family is different. So while we're talking about these broad terms and we're giving you definitions, especially now, it's so different from when we started practicing where, sole custody meant that one person would make the decision and they would have to advise the other person. A lot of times now we're getting decisions where one person has sole custody, but they still have an affirmative obligation to consult with the other party and to try to discuss the issue. So I think that the court is really trying to factor something that works for each family.
So we have a question, Siobhan. If I have sole physical custody, do I have to consult with my ex for their activities? What is your thought?
So it really depends on what the agreement or judge's decision says, what the document that awards you sole legal custody, because Jennifer's right that the basic definition of sole legal custody, I would say no is my answer, but your agreement or decision may actually have a morph of joint legal, and a lot of judges have done that in recent times where they'll say mom has sole legal decision making, and then she gets final decision after she consults. That's actually like combining three different things. So I can't really answer that specifically without seeing the document. So you would really have to consult with an attorney on that to have the attorney read the document. I want to just add one thing. Sorry, I meant to say this before. You in New York anyway, you are presumed that if there's no order or agreement, you're presumed to have joint legal custody. So a lot of people don't understand that when you're going through the divorce or when you're just, maybe thinking about going to family court. If there's no order that awards somebody decision-making, or there's no divorce that awards somebody decision-making, the presumption is that the biological parents share joint legal custody. So no one has unilateral authority to do anything really.
So let's just clarify that for 1 second, Siobhan, because we know that there are a lot of parents who actually get final decision-making or sole legal custody. So while there's a presumption while you're going through your action, that doesn't necessarily mean that New York has a presumption for
Correct.
Legal custody. Okay, so, and I see that there are people from other states here, I believe. And so I just want you to realize that New York may be different than California, that may be different from Illinois. Each state has its own rules, and so you need to consult with an attorney in that area. Jennifer Jackman, Siobhan O'Grady, and myself are all New York based. Ellie is actually out of Pennsylvania, if I'm not mistaken. And so just be careful, because most of what we're going to say, just, take it and then go back to an attorney in your area, because the presumptions may be different in New York from other areas. So Ellie, this is like my favorite app of all times, okay, is our Family Wizard. Our Family Wizard has saved us on many, many cases, because it is, it just does so many things. So tell us about our Family Wizard and why it is a useful app, even for things like spousal support when somebody's late, or add-on expenses, or any of those kinds of things, communication.
Well, I am the #1 fan of Our Family Wizard. I'm a fan of you as well. I'm thrilled to be here tonight. Thank you everyone for joining in. Savvy Ladies is a wonderful resource, just like Our Family Wizard. Our Family Wizard, it's a resource for co-parents and for family law practitioners. It's an app that you can put onto your phone. It's also a website. It helps parents manage all the responsibilities and all the complexities that come with raising children in 2 separate homes. So what we know, what we see as divorce attorneys and financial pros and mental health pros is that parents come into the divorce process and they are emotionally overwhelmed. They are uncertain and they are completely unprepared to deal with all those complexities and all those responsibilities that come with co-parenting. So the Our Family Wizard platform, it was thoughtfully, carefully, and intentionally designed and built with every single tool to anticipate every single shared parenting need. So through the platform, parents can schedule parenting time. They could put their parenting schedule on. They could schedule events, appointments, birthdays, holidays. They could document their exchanges. They could share information, photos, documents. They could manage and track their expenses. So all those add-ons that Lisa just mentioned, every single prescription, every single extracurricular activity, all the tutoring expenses, all of those add-ons could get put on. They could be managed, they could be tracked, and they can actually be reimbursed through the platform. Parents can also send secure messages that cannot be manipulated. Once a message is sent, it is locked, it cannot be edited, it cannot be forwarded, it cannot be retracted or deleted. And all of those communications are preserved. So it's this wonderful, invaluable platform with every single co-parenting tool you could possibly or imagine, like that you would need as you're going through a separation or through a divorce.
And in terms of, I know that there's something called the tone meter. Can you explain what the tone meter is?
It is my very favorite co-parenting tool on the platform. So co-parenting, it is not easy. It doesn't come naturally. One of the main issues, other than managing and dealing with finances, that we see parents facing during a divorce or separation is how to communicate effectively. So our platform, and specifically our messaging feature with the tone meter, it serves as a playbook or a blueprint for co-parents so that they can communicate productively and effectively. The tone meter essentially is an emotional spell check. So in real time, as a parent is drafting a message to their co-parent, they will have the tone meter there assisting them. And I can share my screen and actually show you what this looks like. It's super cool. I have my demo account open, so I'm going to share my screen real quick. Fingers crossed this is going to work. Can everyone see my screen?
Yes, we can.
Okay, fantastic. So this is what the platform looks like on the website. This is what you would see if you log in as the parent. And when you drop down to messaging, when you're drafting your message to your co-parent, I'm going to put here, I'm logged in as the mom. So I'm going to draft the message to dad. I'm going to copy the GAL and I'm going to copy the mental health pro. So now I'm going to start typing my message and I'm like super frustrated. Dad didn't show up on time for the exchange. I was waiting there with half an hour for the kids. The kids were cranky. They were hungry and tired. So I'm pissed.
So was the person waiting, by the way.
All right, here we go. Where the heck were you? I'm not going to use any curse words or profanity. Why are you always late for a no-show? It makes me so mad. I can't believe I had children with you. Okay, and this isn't so bad. So we see here the red bars pop up, and this is what it looks like on the website. When the parent's actually typing on the app on their phone, those bars are going to pop up right away and they're going to have to click them off. So the tone meter is going to tell them, you know, your tone is being aggressive. It'll also let the parent know if the message is going to come across as upsetting, humiliating, disparaging. It'll put the adjective that's appropriate for whatever tone the artificial intelligence is picking up. It's not going to prohibit the parent from sending it. It's going to alert them. And what we know, the feedback we've received and from working with families over the past 20 years using this platform, this has been around for about 10 years now, is that it really helps parents communicate more effectively. It gives them that reminder, the time to take a step back and really think about what message they want to send to their co-parent.
This is great. And everybody saw that word aggressive because Ellie's message, I guess, was aggressive. But I have seen much worse. And I'm going to go to Andrea now to talk about that. So Andrea, first thing, what are the best practices for making a good impression in court? So whether you're in family court or you're in Supreme Court, what should people keep in mind when they're walking into that courthouse?
So I think the thing to keep in mind is that probably in the court's opinion, this is your best self. This is as good as you will ever get. So if you are sitting beside your attorney and you hear the other side say something that you absolutely know is untrue, be calm, do not roll your eyes, stay composed. Your lawyer is there to handle it. I say keep a notebook in front of you and quietly write notes because only you know what's the truth. But that is not the time to become upset or visibly angry with the other parent of your children. Now is the time to be calm, to be reasonable, and to be child focused. Be mindful that this is about your children. This is not about your anger at that person at the other table.
And if people aren't there for custody, but they're there for equitable distribution or they're there for support, would your advice be the same in terms of how you should be conducting yourself?
1,000,000%, because no matter what, this is an opportunity. You have representation. And frankly, even when people are pro se, which I don't recommend, which means they're representing themselves, this is a time to be calm and measured. This is not a forum to let it all out. This is not a forum to roll your eyes or be snarky. It's an opportunity to move away from whatever feelings you had about that soon-to-be ex or ex who may not be paying and not be attached through your emotions. And actually, I divide things when I speak with people. I call them kid issues and green paper issues. And no matter, while you may be very passionate about your children or you may be very upset about money, save that for outside the courthouse. That is not the time or the place. It is a place to put your best self forward and get through the process and not act out, frankly.
And in terms of acting out, what are some of the observations that you've been in court? What are some of the observations that you've seen as to how people act out when a judge is watching?
Want me to demonstrate?
Sure.
People get very exasperated. They throw themselves around, they sigh, they roll their eyes, they throw up they hit the desk. They start to speak, especially if they have counsel. The judge is not speaking to you. Unless the judge directs something to you, please don't speak. Please be composed. Please be calm and do not be reactive or even responsive unless a response is asked of you. Because in those moments, you are being watched. And by the way, if you think the judge is over here, there's a court attorney. There's a court officer. There is someone there that you aren't even realizing is taking internal memos about your decorum and your behavior. And if you were ever accused of being inappropriate or being overly angry, and you do one of those things, you're validating the concern on the other side. And that's the last thing you want to do.
And Andrea's point about the court officers, and I see both Jennifer and Siobhan shaking their heads because we all know actually, that the court officers who are in the hall, who are in the courtroom, you're thinking that they're not paying attention. The stenographer who is taking down all of the testimony or all of the things going back and forth that people are saying, those people go back into that back hallway or those back rooms and they are speaking to those judges. Did you see that woman? Did you see how she reacted? Did you see that guy? Did you see how crazy he looked? Do you see that, judge? And believe me, it makes an impression. How many times, Siobhan, have we seen that? How many times, Jennifer, have we seen that and heard it from the court officers?
I was going to say that, a lot of people assume like when I'm in the courtroom, I have to be on my best behavior, but it's actually the moment you're at the outside door of the courthouse, because there's court officers and staff walking in and out of the building, at the magnetometers, in the elevator, in the hallways, and they are watching. They're sitting there watching all day. It's like a TV show to them. They're just watching people's lives unfold, and they're talking about it when you leave. And if you have an outburst in the hallway, or if something happens in the elevator, they all talk about it for days, and it trickles back to the judge. So I tell my clients, you are on your best behavior from the moment we get within 10 feet of the courthouse door, and you do not let your guard down until we were outside and away from the courthouse again.
And that's how you interact with even your own lawyer. The looks that you're giving opposing counsel and the attorney for the child, they do see, people notice, and they absolutely talk. We understand that it's an emotional time, but you're in that courthouse and before that judge for such a limited time. To make a bad impression is just, it's not good, and it does color your case. So you definitely don't want to do that.
And don't think if you're in a courthouse that has plexiglass around you when you're with your attorney, that people aren't watching and still can't hear, because they do see and they do hear, and you may be frustrated. Save it. That is not the place.
And that's I would say, of everything that you have to remember, that's one of the most important things to remember, because that can really, your testimony could be great. You could have the best case, but if you catch that eye of that court officer in a bad way, or that judge, that is a very bad way to go. You have to really watch yourself. So, Elle, talk to us about the ping device on the Our Family Wizard, and tell us how it works.
Sure. We have a new feature. It's called the check-in tool, and it's incorporated as part of our journal feature. And back in the day, I'm sure Lisa is going to remember this, before apps, before GPS tracking, we had judges ordering litigants to go into a McDonald's or go into a Dunkin' Donuts and purchase a coffee to prove that they were at the exchange at the time that they were court ordered to be there. So now, instead of going in and purchasing the coffee and saving the receipt and having it crumpled with a bunch of other receipts trying to prove that you were where you were supposed to be, Our Family Wizard has this check-in tool where either parent, they turn their location services on, they could drop a pin. It can only be done on the app, on the phone, and that pin will drop within 500 feet of their exact location. It'll document the date, the time, and the latitude and longitude of that location. It cannot be tampered with. And what we see this being used for is when, number one, there are allegations that a parent is not arriving on time for an exchange or for an event, or number two, when there are false allegations. A parent can drop that pin. They don't have to share that with their co-parent. They could drop the pin, do the check-in, and save it as a private check-in. So if there are false allegations being made, the parent can use that as a tool to protect themselves. They can share it with their attorney. So when they go back to court, they print out a report of all their check-ins from the past 90 days. I was there. I was at the exchange every single Wednesday at 5 p.m. and here's proof of my check-ins. It's a fantastic tool, and we're seeing it being used more and more by parents, especially in the cases where there's false allegations.
And the courts actually are recommending to use it. We've had judges, I know Siobhan was with me when we had a judge actually say this is what you should use, so that you never have to hear that, him say that you're late. You've got it, and you've got your proof. Okay, so this is a big question, Andrea. So a lot of people come to me and they tell me one of the very first things is he's a narcissist or she's a narcissist. Okay, how do we deal in divorce when you're divorcing a narcissist? How do we deal with that?
So I think the first thing that I tell people is, tell me what you mean by that, because it can become a catch-all phrase. And even a mental health professional, if you're in an action, you're not there to diagnose. So it can be very descriptive. And usually what people mean is somebody is incredibly selfish and self-interested, doesn't put them first, hasn't put the kids first. And they're very frustrated because it's always been that person's way or the highway. And now they're confronted with, to your points, there's a presumption of each of you is going to have parenting time. Each of you has decision-making abilities. And what I say to people is that may be so, but you're going to do your best to foster a relationship between your children and that person who's their other parent. Your children are 50% each of you and 100% themselves. So we are not going to make your children feel badly about their parent or their guardian because they will feel bad about themselves. And you will take the high road at all times, even if that person takes the low road. So if they write a nastygram and they're not on OFW, which I wish more people were, you're not going to nastygram back. You're going to take a breath and you're going to sort out what the communication is. And I would say don't be attached to who that person is or how they are. If there's children involved, focus on your children. And if it is only a financial matter, then focus on what the goals are, which is to get out of this and be done. But do not take the low road. Do not meet them where they are and do not fight back. It does not work.
And would you give the same advice if there's no children involved? People come to me because, again, equitable distribution, spousal support, right? How do you deal with that lying, narcissistic personality, who you're afraid could be so charming, frankly, in that courtroom? Because that's what they say, right? Is, Lisa, I know that you can do the job, but he's so charming or she's so charming, and I just don't know anybody's going to believe me.
So here's what I would say, which is number one, really have faith in your counsel to represent your best interests. That's why you're with an attorney. And number one, don't worry about what they say and do. Know what you know, document it for your attorney. What you share with your attorney is between you and your attorney. Any of the history, anything that you have proof of that you know occurred in the course of your relationship, provide to your attorney. And a good attorney knows how to ask those questions well of the other side, is not emotionally invested the way you are. Let them do this on your behalf. Don't go into court and be enraged if the judge happens to seemingly be wooed for the moment. To me, when people say, why can't this be over already? My attitude is sometimes time is on your side. And that veneer that you're so concerned about starts to chip away. And Lisa, you know this as an attorney, in the course of discovery, documents speak for themselves. That it doesn't quite necessarily add up to what that other person said.
And that brings me, to the issue, and Siobhan, I think you could speak to this. There's a lot of cases that take a long time. And what advice do you give people who are going through this? And sometimes it's 2 years, 3 years, it could be 4 years. I mean, it doesn't happen overnight, particularly in terms of people who started before COVID or unfortunately in the court system, and COVID has really taken over in terms of the scheduling.
So that's incredibly frustrating. And I feel very bad for a lot of our clients because there is really no way to move it faster than we do. We move as fast as we can, but we're also limited by the court's limitations and the court's backups. And also, the other side might be playing games. There might be delays. There's certain things we can do to combat that. We can file motions. We can ask for certain penalties. But I think Andre makes a good point, and this has happened in quite a few of our cases recently that have gone on for what the party thought was a long time, and we got critical evidence or an incident occurred in the later stages that really turned the entire case around. So sometimes time is on your side, particularly when you have a manipulative litigant on the other side. They generally can't hold up that facade the whole time. They're going to crack, they're going to make a mistake, they're going to do something stupid, they're going to slip. And we're kind of waiting there to just gather it and then present it to the court. So what I would say is you have to make sure that you have a good relationship with your attorney. You have to get a good working relationship where you're picking your battles to some extent. especially when you have a long drawn out litigation. You're not fighting over every little thing. You're really choosing where it's most cost effective or where the most important issues are. I hear Lisa say this all the time. You know, you may be thinking about this, but I'm thinking about this because it's a bigger issue for you and it's a more important issue for you. So that's what I would say. I think you have to really, you have to have a lot of patience with the court system because it's very slow. The wheels of justice are very, very slow.
And it's an interesting point that you make. So Jen, you might not hear me say this all the time, but I often say to people, please don't distract me. Okay. And Siobhan hears it all the time. Actually, I say it to people, but what do we mean by that? Because everything is important to people when they're going through a divorce or custody. What does it mean for us to be distracted by certain things?
So I think exactly what you said, you know, so many things are important to you because it is your life. But getting you through a divorce, there are things that we know that we have to focus on, things that we know are important. And so what Andrea said about having a good relationship with your attorney and trusting your attorney to help you through the process. It isn't an easy process, and we don't have a lot of control over how quickly it goes. And I think you do have to be prepared for that. And what I tell my clients is that even though you still have this big thing looming, you still have to live as you're going through it. And somehow try to think about what your life is going to be like when you're done and when you're through your divorce. But focusing on the big issues and not the small things, because it is a distraction and then it's an unnecessary complication that sometimes can be costly and can set your case back for no reason, really.
And Elle, you mentioned being able to pay support through our Family Wizard. So let's talk about add-ons. What are add-ons? Define what add-ons are, because I think they're the bane of everybody's existence, frankly, who have children.
They are, absolutely. So add-ons are all the expenses outside of child support or what the parties agree to, what would be considered outside of child support. So for example, I just had a case where the dad was paying for Band-Aids and ice packs and Advil. And then he got another receipt where he had to pay for over-the-counter medication for, it was some type of asthma medication. And so that was not agreed upon as add-ons. He was required to pay unreimbursed medical expenses, prescription costs over $25 to split. So those add-ons are all of those unreimbursed medical expenses, extracurricular activities, and each party will agree or negotiate or be court ordered to pay a specific amount of those add-ons.
And what does our Family Wizard do in terms of this? So tell me what is helpful about our Family Wizard for this.
Our Family Wizard has an expense log. So this feature is where parents can accurately, they could track, they could manage, and they can request reimbursements for all of those shared child-related expenses outside of child support. In some states, we have parents also paying child support through the expense log, but for the most part, the expense log is being used for those add-ons. So what parents do is they don't reopen the dialogue. They're not engaging. They fill out fields. It's a request for reimbursement form. They put the date, the expense, the category, and parents will set up the categories based on their split, whether it's a 50-50, 70-30, and they could have different splits. So let's say unreimbursed medical expenses are 50-50, where extracurricular are 70-30. So they set up their categories, and when they're filling out those fields, they click the category, the amount, the date, and then they attach the receipt, whether it's a screenshot of the Amex payment, or they actually take a picture of the receipt after they purchase whatever it is, the prescription medication from CVS. They add it on either through the app on their cell phone, or if they're at home and they log into the website and they have it saved, they upload it onto the expense log. The request goes to the co-parent. The co-parent can then approve or refuse. If the co-parent refuses, they put an explanation why they refuse. If they approve the expense, they could then go to OFW Pay, which is essentially a built-in Venmo, PayPal, Cash App. The parents link up their bank accounts and they could then transfer the funds for that expense. So there's double, triple layers of documentation from the request for reimbursement, the attached receipt, the response, and then the payment. And this keeps parents super organized. It streamlines the expenses. It reduces the conflict. And in turn, what it does is it benefits both co-parents, improves the relationship. It makes the co-parenting relationship more healthy. And in the long run, it benefits the children. And the parents can then focus on raising happy, healthy, and resilient children, not fighting over a $50 copay for an urgent care visit and who pays what and how is it going to be split and did you pay or did you not pay, and then going to their attorney and spending way more than the actual expenses to go back to court and file an application or hold a parent in contempt for failure to abide by the marital settlement agreement. So it's an invaluable tool. It is going to help you when you're negotiating and even to visualize and see how your expenses are going to be split. You could start putting in there, not even requesting reimbursements, but you could start just managing your expenses and seeing what your expenses are and how this is going to play out for you.
So Siobhan and Jennifer, I want one of you to talk about the calculations for spousal support and one of you to talk about the calculations for child support. So Siobhan, what if you take spousal support and explain what a cap means, what the factors are in calculating spousal support, what happens if there are a lot of assets, what could happen in terms of spousal support, et cetera.
Sure. So spousal support is also known as alimony or maintenance. There's different terms for it. And there is temporary maintenance. I'm going to call it maintenance just because that's the way I think of it. But so there's temporary maintenance and then there's post-divorce maintenance. It's the same set of calculations for both, but temporary maintenance would be applied if the court was to award that or the parties agreed to that during the pendency of the action. And then once your judgment of divorce is issued, it would be post-divorce maintenance. So it's sort of like two separate time periods. There are guideline calculations that are applied to the parties' incomes to determine what the maintenance that would be paid. And generally speaking, it's not every case, but in a lot of cases, the courts will follow those calculations. The calculations are based on what's known as a statutory cap of it's currently $203,000 of the payor's income, just the person paying support. That person's income is capped at $203,000 for the purposes of the calculations. And then the court has the discretion to go above that cap and go all the way up to full income. So they can go anywhere between 203 all the way up to full income. And the calculation, the formula that's applied, there's two formulas. One formula is applied if the person paying maintenance is also paying child support. And the other formula is applied if the person paying maintenance is receiving child support. So it's really based upon who the custodial parent is and which direction child support is running, which I'll let Jen handle. But maintenance, there's basically two different formulas. They're slightly different. One is known as like the higher formula and the other one is known as the lower formula. But you apply them to the incomes, it spits out a number. And then you can go all the way up to full income. So you might end up with a range of, it could be as low as this, or it could be as high as this. And the other thing they look at is the duration of the marriage. So the duration of the marriage goes from the date of marriage to the date of commencement of the action and how many months you were married or how many years and months you were married. And you apply, there's three separate periods. So it's 0 to, I'm going to screw this up. I think it's 0 to 15 years, 15 to 20 years, and then 20 plus. Those are the three areas, the three durations, and it's a certain amount of percentage of the month. It's all math. It's not all that complicated. You basically just need to figure out your incomes, and then we can apply those numbers. And that's how the court would do it. The factors, the court has a whole list of factors they consider with whether or not they're going to go above the cap. So that's what Lisa was saying about the factors and the assets. They're going to look at whether someone's losing health insurance. They're going to look at whether what the assets are, what the earning potential is, what the past history is, what everybody's ages are, what their health is like. There's a whole there. I think there's like 15 or 16 factors that the court will look at to determine whether or not they're going to go above the cap. So that's maintenance at a very high level nutshell.
And in terms of maintenance, there's not really, besides the statutory cap, there's not really caps that are above the statutory cap like there is child support. Like we look more at lifestyle, correct?
Correct. One of the determining factors, one of the things the court will look at is the lifestyle that the parties would have enjoyed if had the marriage continued intact, and particularly for pendente lite maintenance or temporary maintenance during the pendency of an action. The court is really looking to, they say like tide the party over till the post-divorce. There's a certain language that they use in the decisions, but the court really has the ability to sort of even the playing field and not let a moneyed spouse, somebody that's the earner in the family, run over the other spouse during the divorce. There's a lot of different ways that the court can help with that, with maintenance, also counsel fee awards, and then also child support.
Now, with regard to the actual, you talked about it depending upon the assets. So if someone has a great deal of assets, those assets are going to throw off interest income, dividends, distributions, perhaps depending upon what all of that is. And how will that affect maintenance?
So the maintenance, when the court's looking at your income, they're going to look at your last filed tax return. So when they look at your last filed tax return, all of those different income producing assets are going to generate income for you in the prior tax year. That may be used for the calculations. So if you may not be working and you may not have any wages, but if you earn $200,000 in interest income in the prior year, that's going to be used as your income, or likely used as your income for the purposes of maintenance calculations. So there's very full and free financial disclosure. If you're not turning it over, the other party is going to figure out a way to get it. So you're not going to be able to hide like tax returns and tax reporting documents. Those documents get turned over, and then the court looks at that to figure out what everybody's income is.
And in terms of the discovery, what we always find in complex cases is that discovery is not easily turned over. And so then you have to make motions to compel, motions to get the discovery, depositions, all of those things. That's what takes so much time. Am I correct?
Correct. And there is a lot of remedies and discovery vehicles for us to use to get the discovery if the other party is not complying. But I do think my impression of any of the courts that I've appeared before is when a party is playing games and trying to hide information, it usually doesn't work out for them with the court, because all the courts know it's very full, free, and mandatory financial disclosure. And if I have to jump through hoops to get your tax return or your W-2s or your pay stubs, generally speaking, the court's not going to like that.
Now, Jen, can you talk to us about child support calculations?
Yes. So child support is monies that's paid on a monthly basis from one parent to the other. As Siobhan mentioned previously, the custodial parent, the parent who has the primary physical custody, is usually the parent who receives the child support. That is a number that is also calculated in New York by statute. We have the Child Support Standards Act, and that is the law in New York that gives us the formula which to calculate child support. In New York, custody is only until 18. You don't have a custody order after the age of 18, but you do have to support your children until the age of 21. So I saw that there was a question about child support for college-age children. And basically, the court is going to determine who the primary custodial parent is, literally for purposes of child support, and that parent is responsible for maintaining a home and buying clothes for the children, and the add-on expenses, then everything else would be divided between the parents.
So we have a question. I think it's an interesting question. What do courts look at when one spouse is self-employed and potentially not running their business as profitably as they could? How could the argument of underemployment be used? So Siobhan, do you want to take
Sure.
that one?
So when I talk about the calculations, and we're talking about the easy calculations when we talk about a tax return and a W-2, there's always the other level of a self-employed business owner, a cash business, somebody who has a partnership interest that you don't know. Those are the more difficult cases to figure out and determine what someone's income is. In those cases, the court has the discretion to do what's called imputed income to a person if they can't figure out what their actual income is. And that can be used for somebody who is underreporting, underemployed. You have somebody who's just not working, but they have the ability to work and they have historic earnings of a certain amount of money. You can prove that to the court with prior tax returns, prior earnings, and then say there's no disability, there's nothing stopping them from working. They're choosing not to work to avoid their financial obligations. So the court has the ability to impute income to either party. They just have to, what's the word I'm looking for? They have to actually articulate in their decision. I'm looking for the word articulate to actually articulate it. They have to articulate in their decision the basis for their determination as to why they're imputing income and how much they're imputing. So that happens in a lot of cases, but that would cover the case that you're referring to about somebody who has like a business that they're maybe running personal expenses through the business, or they're not earning as much, or they've fudged their numbers for their divorce year. There's a lot of different ways that presents in financial litigation.
Right. The bottom line is the court does not have to accept a party's account of their finances. The court doesn't have to do it. And again, this is what takes so long, because if you know that they're doing things deliberately to hide their income, then we have to go looking, and that takes time.
And I'm going to also say, so there's a couple of things about imputing income. Number one, sometimes you may have a spouse who is not working up to full potential. There is a way to deal with that, which is to have a vocational analysis performed. That's one issue. That's usually done more with a W-2 employee than it is a business owner. In terms of a business owner, you're probably going to need a forensic accountant. Last week we had Gary Rosen on. He is a forensic accountant from Markham. He's also on the board of Savvy Ladies, but he is one of the types of people that will do an income stream analysis to figure out what somebody's income should be. He will also make sure that he looks at the expenses that are being written off from the business that really should be put back in as income. So for example, they're writing off 100% of a car. They're writing off their mortgage. They're writing off, I mean, just about all those things can be put in, because if they weren't writing those items off, if those items weren't being paid directly from the business, they would actually be paid from their income. They would have to take their income, pay the taxes like the rest of the folks, and then you would have the income. So they do that analysis. People look at the loans that are taken from the business, because sometimes there are business loans that are taken that also should be imputed as income, because they're never paid back, ever, ever, ever. They're not paid with interest. They are just simply loan after loan flows from the business, and nothing's ever paid back. Those can be imputed in it as income too. And you just need to know where on the tax returns to start looking for that. So that's important to know. Jen, people ask all the time, and we're going to end with this question actually, in terms of child support, these caps, right? So sometimes child support is capped at $163,000. Sometimes it's capped at $300,000. Sometimes it's capped at $400,000. Sometimes it's capped at $500,000, right, of combined income. So how do they know what it's going to be capped at? How do they do it?
The court has absolutely no discretion up to 163. That is the number that we're using, at least for now. I think it probably changes maybe in April or May or so of 2024. But for now, 163, there's absolutely no discretion. Anything above 163, the court has a lot of discretion. And I would say that it does depend. You can do the formula to the entire amount. You can cap it at a number, whatever number the court determines is reasonable based upon the circumstances. But I think it really is by jurisdiction where you are, New York City, Westchester, or Putnam, you know, what the courts do and how much income they're going to use. I don't think there's really a hard and fast rule after the 163 what they do. They can apply the statute or they can deviate from the statute.
Somebody asked the question, when a divorce takes a long time, does the court look at the most recent tax returns or only those covering the period before or at commencement? And I would say, and you guys jump in, I would say that it depends. It depends on what has gone on. So if you have a long, history and all of a sudden there is a drop in income, for no good reason, the court is not necessarily going to be held together by those tax returns. But it's tax season, everyone. And so I'm going to also say be careful about signing those joint tax returns without indemnifications, because those indemnifications that we write, for example, say that you are not admitting to the veracity of the income that your spouse is claiming, which then gives us the ability to go in and actually say, hey, you know what? That's not the income that we believe the person that can actually earn or that the person is earning. So I think that's really important. There's also a question here, whether taxes can be filed separately if no paperwork has been filed with the court. I'm gathering that somebody is asking if they are separated in some way or even living together with their spouse or contemplating divorce, but nothing's happened. Can they file separate tax returns? And the answer quickly is you can file separate tax returns. You can file married, but filing separately. But you must be careful about this because someone may think it's a wasteful dissipation of assets in that you refuse to file with your spouse and therefore cost the family unit more money. When you don't file jointly, it usually, not always, so you have to consult with an accountant, it usually will be more costly to the family unit. And the court can take that as a wasteful dissipation because you cost the family more money. A little trick, however, is you can modify, usually amend tax returns if you filed separately, but you cannot amend from joint filings to separate filings. So if you file jointly, you're not going to be able to amend. If you filed separately, you can go back as long as the timing is okay and amend those tax returns to rectify the problem later. So that's another answer. So ladies, we do have...
Lisa, I'm sorry, can I just say one thing about money because it pertains to what I do?
Sure.
And it particularly happens with kids. I beg people, please do not put your child in the middle in a conversation about money, about your parents should pay this and I'm supposed to pay that, and go ask your dad or go ask your mom or go ask your other mom. Please leave your children out of that. It's really not their problem that they don't have one house anymore, that they may have two. And it's really for the adults to sort it out. And if there's an agreement or a decision, then it falls to that. But it really hurts kids when they're put in the position where they think they have to negotiate with their parent. I really advise against it.
Thank you, Andrea. And I'm going to, it's 7:03. I know that there's more questions in the form, in the chat, and we're going to have another session next week. We have a great panel next week, and I invite you all to come back. Actually, it is, Tracy, next Wednesday, am I correct? At 6 o'clock, we'll be sending out notices, and we also invite you to utilize our helpline. And we have phenomenal financial professionals on the helpline who can help you with your financial questions for free. So, please, and I thank our sponsors again. Ellie, thank you. And thank you for our family wizard, and Siobhan O'Grady, my partner at Miller Zeiderman, and Jennifer Jackman, my partner at Miller Zeiderman. Thank you for all of the information. And thank you, Andrea Labus. So everybody, thank you.
Thank you all for coming. Sorry, I'm having all kinds of technical difficulties tonight. I will go leave these slides up if you wanted to take a look at them. They were frozen in the beginning. So go ahead and leave those up for a moment. And I just, on behalf of Savvy Ladies, thank you ladies for being here. I know that I've learned a lot, and I'm sure our participants did. Again, please feel free to reach out to our one-on-one pro bono helpline. We are here for you.
Thank you. And please, by the way, we have lots of events that we do, so please feel free to come to them and all of our panel discussions and be a part of Savvy Ladies.
Thank you, Savvy Ladies.
Thank you.
Bye-bye.
Thank you. Good evening, everyone.
Thank
Have a
you.
great
Thank
night.
you.
Have a fabulous
you.
night. I hope it was helpful. And we're
Thank you.
here next
Thank you.
Wednesday, same time.
Thank you.